everyone, my name is Geetanjali Singh and the topic for today's video is voyeurism. Now in this video we learn about the history of voyeurism and its introduction in Indian law and the concept and the need for voyeurism and several legislations according to it. Now voyeurism under Indian Penal Code of 1860 is being described under section 354C, which describes the act as viewing and or capturing the image of girl or woman going about her private acts or activities where she thinks that no one is watching her, but the person that is being doing this is watching her and is a crime. Now this includes a woman using a toilet or who is undressed or in her underwear or engaged in any sexual act. Now, voyeurism in a broader perspective implies that act of gaining sexual pleasure from watching other people while they engage in sexual activities or are naked. Voyeurism is a paraphilia that involves sexual pleasure from viewing unsuspecting individuals undressing, already nude or semi-nude, or involved in sexual activities. It can also be defined as a habit of spying on people doing actions that are generally regarded as private, such as engaging in sexual activity or undressing. In voyeurism, the person being observed may have no connection with the voyeurer in any way. The kind of obsessive behavior can also be called stalking. Voyeurism under penal code, it was beforehand it was not there. Now private act under this provision describes an act of watching carried out in a place wherein circumstances would reasonably be expected to provide privacy. Any other person or at the behest of perpetrator or disturbing such images shall be punished on first conviction with imprisonment of either description for term not less than 1 year, but which may extend to 3 years, and shall also be liable of fine and punishable on a second or subsequent conviction with the imprisonment of any description for the term not to be imposed. Now, the history of voyeurism and its introduction in Indian law is that the term voyeurism has its roots from French. Voyeur means the one who looks. It was introduced in the Indian Penal Code 1860 through the Criminal Amendment Act of 2013, which relates to sexual offences. The amendment came after the outrage in the nation at the time regarding the brutal gang rape in 2012 in Delhi. Previously, under IPC, there was no specific offences, and under the IT Act 2002, however, men and women were covered. The penalty was up to 3 years of fine or for up to 2 lakhs of the act. Now, what was the need of the provision in Indian reject? The Criminal Law Amendment Bill 2013 was introduced to amend the existing provision that was weak in the criminal law with regard to improve the safety of the woman, so that people may fear of committing any crime. There was a huge outrage across the nation following the brutal gang rape in Delhi, known as Nirbhaya Delhi gang rape. And previously, there was no clear definition and scope for intrusion of privacy. The offence is usually combined with the other forms of harassment or violence and is not considered as a separate offence. This section provisions relates to the criminal to have the intention to insult or outrage woman's modesty. It may or may not be an act that actually engage physical endangers an individual's security. However, it may cause the victim mental trauma and fear. In a blatant intrusion into the privacy of individual, where the stalker tries to establish relationship with his victim without his or her consent. And the electronic voyeurism is also covered under IT Act, and the separate section has been introduced in the IT Act 2000 by IT Act Amendment of 2002 by influence of Section 108 of Voyeurism Prevention Act of 2004, a federal law of USA dealing with the felonious act of video voyeurism. Now, the punishment for it is any person found guilty of this offence shall be punished on first conviction with imprisonment of either description for term which shall not be less than 1 year, but which may extend to 3 years, and shall also be liable to fine. Then the second subsequent conviction is not the second accusation of offence only after the accused is being proved guilty. How can a person file a complaint against voyeurism, the victim may file an FIR, and in the case of offences like sexual harassment, voyeurism, stalking, rape, etc., the report must only be recorded by a woman police officer. The woman can give her complaint in written form or even verbally. The officer in charge of the report will have to file a written copy, and the sooner an FIR is registered after the crime takes place, the better. Information given in the FIR should be as detailed and explicit as possible to know that what happened, where it happened, and how did it happen. It is really difficult to explain what has happened to them, but it is at the same time it is really necessary. Any person found guilty of this offence shall be punished accordingly. And voyeurism is one of the most rampant crimes staring in India its face today. This particular offence and the remedy available for it is lesser known amongst us and especially women. One cannot stress enough that the importance of being conscious and mindful of the laws and regulations. Not everyone knows that what laws and regulations they have and what safety they have, especially those pertaining to the protection of women. Not everyone is educated. Now, having well-draft law will not bridge the gap unless they are implemented effectively. The privacy and the keeping their personal information private is also the part of the security of people and also comes under the ambit and scope of our fundamental rights. The criminalization of stalking, acid attacks, voyeurism gives some confidence to the citizens that the privacy rights are being safeguarded. Right to privacy is the very basic right that and is the facet of right to life, which is a fundamental right of every citizen. The sending of MMS capturing the private areas of any person, thereby violating the privacy under the parameters detailed under Section 66E of IT Amended Act 2008 would also be now brought within the ambit of penalty and punished with imprisonment per law. Some people get habituated for the offense, like paraphilia. It is a medical term known for the repetitive offense, accused person or offender of voyeurism, known that it is not correct. Such people not to be need to be diagnosed under the medical supervision, and there is a need to come up with more strict and stringent laws so that a person intending to such crimes loses courage to perform such acts. Introduction of voyeurism as an offence in IPC under Section 354C and certain changes in IT technology can bolster the women's safety in our society, and it's really highly needed. That was all. Thank you.